Hello, welcome everyone to today's Title Topics webinar. These are ALTA's free presentations that we offer every month on issues important to title professionals. I'm Jeremy Yohe, Alta's Vice President of Communications, and today we've got a fabulous webinar lined up to help you understand how to handle transactions involving Native American lands. Before starting, I just need to touch on a few housekeeping items. You can download a copy of today's presentation from the handout section. All of the participant lines are muted for today's presentation. If you have any questions during the presentation, please submit them through the questions box, and we will hold some time for some Q&A at the end of the presentation. And as an added benefit, we are recording today's webinar. Once we have the file processed, recording will be emailed to everyone, typically a day later. And you can also access all of our previous webinars on our archive at alta.org/title topics. That's alta.org/title topics. I do need to thank Fidelity National Title Group for sponsoring our Title Topics webinars this year. Their support allows us to offer these educational opportunities free of charge. And with that out of the way, please I need to introduce today's speakers. First, we have Nancy Appleby. She is founder and managing member of Appleby Law, which is a law firm specializing in commercial real estate and development on Native American land. And Nancy is also chair of ALTA's Native American Lands Committee. And also joining us today is Megan Powell. Megan is commercial agency underwriter for First American Title Insurance Company. And Megan also is a member of ALTA's Native American Lands Committee. So we've got two fantastic national experts on this topic. And with that, Megan, I'll turn the presentation over to you.
Okay, thank you, Jeremy. As you can see on our agenda slide here today, we're covering 5 topics, all of which are important to consider when you're insuring transactions involving land with the Native American component. And before we dive into that first topic, Nancy and I thought it would be beneficial to let everyone know that currently there are 573 federally recognized tribes that are eligible to receive services from the BIA. That number does fluctuate at times. For example, when a tribe applies for and receives federal recognition status, the most recently updated list of federally recognized tribes was posted by the BIA on February 1st of this year, and you can easily find that information online. There's also a few tribes that have state recognition only, but without federal recognition, they're not entitled to the same kind of benefits. So now I'm going to turn it over to Nancy, who's going to discuss federal trust responsibility and sovereign immunity. Nancy?
Good morning, everyone, or I suppose good afternoon for some of us. My pleasure to be here, and thank you for dialing in. So I guess the first question might be, why do title professionals care about federal trust responsibility? And I would start out by saying that the trust responsibility of the government is foundational in federal Indian law and impacts, cuts across basically all of federal Indian law as an underpinning doctrine. In summary, the concept is that the federal government is responsible for overseeing and protecting tribes and their assets. That includes conveyances, or certainly limiting the alienability of certain types of Indian-owned property, taking land into trust on behalf of tribes, requiring federal approvals for tribal action in many instances, all of which set the stage for the discussion of land title and access that we'll be having today. The federal trust responsibility has been around. It was articulated, you can see, it's been around for many, many years, articulated in Cherokee versus Georgia, one of 3 cases back in the 1830s that are very significant to the basic black letter of federal Indian law. In Cherokee versus Georgia, the court declared that tribes are domestic dependent nations who, in exchange for ceding their land, got promises from the United States to protect tribes and their assets. The Federal responsibility, which incidentally is not limited solely to the Bureau of Indian Affairs. It cuts across the entire federal government. And each of the executive agencies have responsibility to consult with tribes and to take tribal land considerations and federal trust responsibility into consideration when they deal with tribes. That responsibility is in the nature of a fiduciary duty. And it's not a fiduciary duty strictly like you'd see in trust law. However, there's certainly a fiduciary duty involved, and typically, with some exceptions, there are some recent exceptions to the federal government's responsibility to oversee tribal assets in particular. Those have come about during what's called the current era in federal Indian law, which is called the self-determination era. And that's a particular phase in federal Indian policy that has developed over the past number of years. Okay, if we go to the next slide, Megan, please. The trust responsibility requires the U.S. to uphold rights reserved or granted to tribes and individual Native Americans by treaties, which I think is important to note. Treaties are actually federal law. They're in the nature of federal law. And often we forget that treaties that were entered into in the 1800s are out there, and they really do impact current dealings with Native Americans and are litigated often when it comes to water rights, taxation, land rights, and the like. They are enforceable today. They didn't just disappear over time, but they are, in fact, often litigated, and you'll see that if you look at the jurisprudence, particularly at the Circuit and Supreme Court level. We see treaty cases quite frequently. So it's treaties, statutes, and executive orders are really the body that we're looking at here of federal law, and they require that the federal government manages tribal trust assets, protects tribal interests, and has oversight approval of tribal transactions. Just next slide, please, Megan. Two of the outgrowths of the trust relationship between the tribes and the U.S. are that, one, title records, Indian lands, are owned by the United States. They are considered to be federal records and therefore are subject to the Federal Privacy Act. And now, when I say Indian lands, I'm not talking about fee property. I'm talking about land that is held by the federal government in trust, so legal titles in trust for the benefit of tribes or individual Native Americans. So the full basket of rights is bifurcated into legal title or beneficial title. And those records are owned by the United States and maintained by the United States. The second principle to remember, or is certainly the outgrowth of this trust responsibility, is the ambiguities will be interpreted in favor of the tribe. There's actually a federal Indian law construction, rule of construction, statutory construction, and that has slipped over into basically contracts, and particularly, this is particularly important for purposes of our discussion today of waivers of sovereign immunity. All right, so the takeaway here, or the practice tip, is to remember that the U.S. is not neutral when it comes to Indian country. It has many responsibilities to tribes under federal law, including the review of tribal transactions when tribal land is involved. And they're, again, typically trust land, but in some instances there are questions about fee land. The failure to obtain approval when it's required is fatal to your transaction. It renders the transaction or the contract void. I don't mean invalid, I mean void, void ab initio. So it's really critical that when dealing with Indian land, with its basic, we're going to talk generally tribal land here, or this would be true with respect to allotted land in many instances. It's important to know when federal approval is required and then to insist that it's obtained. And the way to know when federal approval is required is to assume that it's required, and then to let somebody convince you that it's not. But it's basically to know that when you have trust land, federal approval is likely to be, or well, very likely to be required, with some limited exceptions, a couple of which Megan will mention later. Okay, so the second topic that we're going to talk about derives from the sovereign immunity, or excuse me, the sovereignty of tribes. Remember, they're domestic sovereign nations, according to Cherokee versus Georgia. So let's think about first, what's the definition of sovereign? A sovereign has supreme legal authority over itself and its citizens. Under federal Indian law, the concept is a little bit different, although certainly not entirely different by any means. Recall again in Cherokee versus Georgia, when tribes were declared to be domestic dependent nations, it's basically sovereign nations. But then we take this, we have a little bit of a twist in that tribes are not given full sovereignty as independent nations. And one of the major constraints is tribes are not permitted to engage in international relations. However, tribes do have authority over their relations among their members and themselves. They have very broad authority also over their land. And when I say their land, remember, we have the bucket of rights, or the basket of rights in the land is bifurcated. We have in most instances we're going to talk about today, we have trust title or legal title in the federal government and beneficial title in the tribes. The tribes and the federal government don't talk in those terms. They talk about Indian land as though wasn't that bifurcation. So just keep that in mind as we go along. I mentioned a moment ago that tribes are expressions of federal. They're valid. They're enforceable. They are expressions of federal policy and law. They cannot be ignored. And in some instances, they need to be reviewed when it comes to vesting issues and where, for example, the limits of tribal land are. This is particularly important in any kind of tribal land claims case. Again, I keep going back to Cherokee versus Georgia because it's such a seminal case, but another of the three cases, and we're going to mention these two, was Worcester versus Georgia, and again, 1832. We're back in the early 1800s. In Worcester versus Georgia, it takes that tribal sovereignty issue a bit, the domestic dependent nations language a bit further to make it clear that tribes are self-governing. So they have a distinct identity, and they are self-governing political entities. They have a right of self-government, notwithstanding that they're dependent on the U.S. So it's kind of an interesting mix of a relationship, but tribes do have the right to self-govern, and they have inherent sovereign rights, including the power to determine the form of government, the power to make and enforce laws, the power to govern their members, the power to tax, the power to determine conditions for membership, the power to exclude, the power to regulate property, and immunity from unconsented suit. All sovereigns have immunity from unconsented suit. So tribes are really no different than if you were dealing with a sovereign foreign nation, for example. And if you can wrap your mind around the notion that tribes are a take, if you will, like not entirely the same, but a take on a foreign sovereign government, then this whole business of sovereignty and sovereign immunity may make a little more sense to you. Because sometimes I think it's hard to grasp, particularly when folks don't understand that tribes are in fact sovereigns, again in a dependent kind of way, I suppose, or a limited kind of way, but they nonetheless are sovereigns. Now I will say that I just characterized tribes as dependent sovereign nations, and it's kind of a limited kind of way, tribes will argue, will posit that they have inherent rights and they are not limited, and that is a position. And the other position the federal government often takes is no, there are limitations. So there isn't always clarity here. But we try to give you an idea of what the overriding, the umbrella look, if you will, or the overarching look. Okay, so as a corollary to the tribal sovereignty, and Megan, please go to the next slide. State law doesn't apply to tribal Indians or Indian reservations unless Congress provides otherwise. Now, there are some examples. Public Law 280, for example, granting a number of states jurisdiction over tribes and their members. That's an example of a grant of state authority over tribes. However, you should assume that unless you're in one of the 280 states, and you can find that out here's a partial list, and also there's you just read the research is pretty simple to figure if you're in a 280 state. State law is not going to apply within the exterior boundaries of the reservation as a general rule. However, having said that, if a tribe conducts a business outside of what I call tribal lands here, but let's call it outside of the exterior boundaries of its reservation, then state and local law does apply. However, conducting business outside of tribal lands does not itself constitute a waiver of immunity. And there's a Supreme Court case directly on point there. So because a tribe is not doing business on its land within the confines of its reservation, and even if it's doing business on its own fee land, let's say it's purchase fee land, it still has immunity from suit. Okay, so we mentioned that one of the sovereign powers is immunity from suit. And I'm sorry, I flipped over something here. My bad. Well, here's a quick recap of what we've just gone through. Again, your little summary there. So let's go ahead on over and talk about specifically immunity from suit. So why do you care? I mean, why do title companies care about this issue? Well, I think largely whether the immunity from suit by a tribe or a tribal entity that also has immunity from suit, whether it's properly waived, will impact the enforceability of an insured instrument. So let's say you're insuring a leasehold or a leasehold mortgage. If the tribe's or the entity's immunity from suit is not properly waived, then you simply will not be able to enforce that document anywhere, anytime, anyhow. It isn't as though you can take the tribe to tribal court. That just doesn't work. You have to have the waiver. Also, if you are concerned about subrogation rights, that the immunity waiver will come into play there as well. Okay, so that's some general principles. The tribe is immune from suit unless Congress waives that immunity, or unless the tribe, and I use tribe broadly because we include tribal entities that also share the tribe's immunity, unless Congress or the tribe waives the immunity. There are certain federal statutes in which Congress has specifically said tribes don't have waiver. They are few and far between, however, and typically do not apply to contract cases, at least kind of your run-of-the-mill contract cases. It's certainly not mortgage law. 2, sovereign immunity extends to tribal officials when they're acting in their capacity, basically in their official capacity. 3, entering into a contract by itself doesn't waive immunity, even if the contract has a waiver incorporated into it. That's not enough. A waiver requires, and the next point is, the constituent documents of the tribe and or the entity may very well require that a waiver take a certain form and have certain language. There may be some specific words that have to be used in order to waive the immunity of the entity. But the broad rule, the general rule is that specific action by the governing body, whether it's the tribal council or whatever its governing body is, or the governing body of the entity, specific actions required in order to waive. Entering into the contract is not enough. So it's important that you review the constituent documents in order to determine whether there are specific language that should be, even if it reflected in the waiver. Okay, so if we go on to the next slide, we're here. Waivers are going to be narrowly construed, and they're going to be construed against the non-tribal counterparty. So whoever's the beneficiary of the waiver will be read narrowly and construed against that party. The waiver also is very likely to limit remedies or resources available to satisfy a judgment. Oftentimes will not allow a deficiency. And that's something that you guys may not be, title professionals may not be so interested in, but in fact, you will see that kind of limitation typically. Last, the tribal entities often have sovereign immunity from suit, but they don't have power or authority to waive the tribe's immunity from suit. So if you were to see a contract in which a tribal corporation, for example, waives its own immunity, but then turns around and says it's waiving the tribe's immunity, that waiver is just not going to be enforceable against the tribe. The tribe needs to waive its own immunity and would need to sign off on any agreement that it has authorized in order to make that waiver effective. And plus the tribal council, the tribal governing body, has to approve. Okay, so if we look at who's immune from suit, a couple of big categories. There are entities called Section 17 corporations. These are federally chartered, tribally owned, 100% tribally owned corporations. They're not, they are literally chartered by the federal government under federal law. So if you see a constituent document of an entity with whom you're dealing and it says federal charter or charter of incorporation, you need to assume that that is a federally chartered corporation. It might not be, but it's likely to be. Oftentimes you'll see a sue and be sued clause in those documents, that the entity has a right to sue and be sued. Don't be fooled by that, or don't take that as a waiver of immunity. As the general rule, sue and be sued clauses are not enforceable waivers of immunity. They really basically are permission for the corporation to sue and be sued as an entity, as opposed to actually waiving its immunity from suit. Maybe a fine distinction, but nonetheless an important one. Also, business entities, even if formed under state law, may be immune from suit. And again, that may be counterintuitive to you, but there is a doctrine, there's a test under federal law, this is the subordinate economic entity test, where it's a very fact-intensive analysis, but how the entity is formed, what it does, how closely related to the tribe it does, whether it's really independent or performing a strictly business or governmental function. There's this routine and like 4 or 5 step process that courts go through to decide if an entity even formed under state law is a tribal subordinate entity and therefore has tribal sovereign immunity. So again, be careful if you have an LLC, for example, that's formed under state law. I wouldn't assume automatically that that entity is not immune from suit. Okay, and then the last slide is something I've already talked about at the very beginning, why you care about this topic. And so with that, I'm going to turn this over to Megan and let her go through Indian land titles and Indian title searches and recording, and then we'll end with access. Megan, please.
Yep, thanks, Nancy. Okay, yeah, I'm going to get into the weeds a little bit more on some of the title-specific issues. The next 2 slides are really to showcase the amount of land that tribes claimed as their territory versus how much land the tribes lost under the reservation system. And I do want to acknowledge that for some reason these slides don't show Alaska or Hawaii, but there is one Indian reservation in Alaska Alaska came into statehood so much later than everyone else that their allocation of property was handled much differently than the lower 48 under the Alaska Native Claims Settlement Act. But we could do a whole hour presentation just on that, so I won't linger on that topic for now. As I advance to the next slide, you can see the substantial difference between what the tribes viewed as their territory and what ended up being delegated to them under the reservation system. And I'm going to talk in a few slides about how that happened. But first, when we talk about Indian land titles, it's helpful to understand the terminology that's frequently used in that space. So this slide contains a list of vesting variations, all of which I will touch on here. The term Indian country is used frequently in federal statutes and regulations. So in addition to reservation land, that term includes land that's held in trust by the United States for a tribe or an individual Native American, which can exist outside the boundaries of a reservation. It also includes land that's held by an individual Native American in restricted status, and I'll talk about what I mean by restricted status in a minute. So let's talk about reservations. The land comprising an Indian reservation that benefits a tribe was originally designated by treaty, statute, or presidential proclamation. And you'll recall on my prior slide that the reservation lands are much smaller than the territory that the tribes originally claimed. Only a portion of the land was reserved for the tribe, hence the name reservation. Reservation boundaries can be expanded or diminished through litigation, settlement with the federal government, also reservation proclamations granted to a tribe by the Secretary of the Interior in connection with a completed trust acquisition, which I'll talk about in a future slide here. So what you see on this slide are various ways title is held, both on and off reservation, and really the only difference between these two lists is the inclusion of vesting in what I'm calling restricted fee status on reservation. There's an opportunity to hold title and trust or unrestricted fee ownership both on and off a reservation. So let's talk a little bit further about what all of those terms mean. The Dawes Act in 1887 authorized division of reservation land into parcels of land that were called allotments. Like Nancy mentioned before, the beneficial interest in the allotment was conveyed by the United States to an individual Native American called the allottee, which is similar to how we would view a grantee. But the United States maintained legal ownership of the land, so they were acting like a trustee for the allottee. So that's commonly referred to as holding title in restricted status because the allottee is restricted from conveying or encumbering the property without approval from the federal government. If the United States issued a separate fee patent to the allottee or otherwise authorizes by giving their approval the allottee to convey the property, then they're effectively lifting their restrictions, so the property then is no longer held in restricted status. Lands that were not allotted were referred to as surplus lands, and they were often sold to non-Indian settlers. And, you know, the Dawes Act is viewed by many as being largely responsible for the huge reduction in Indian territory that was displayed on that first slide that I showed you. You also see a reference to the Indian Reorganization Act of 1934. This act ended the allotment process, but the damage had been done, and the allotment process resulted in over 90 million acres of land being removed from Native American ownership and control. So today, there's still allotments that are subject to restrictions, but most of the original allottees are deceased, and their allotments have been passed on to their heirs. Over time, that beneficial ownership that we were talking about in these allotments can become so fractionalized with so many heirs who own a tiny portion of the beneficial interest in the allotment, along with several other heirs, that the vesting, the beneficial title for that allotment can be held by many, many different people. It's kind of what we refer, or what we mean when we refer to fractionalization. Okay.
Megan, let me just jump in 1 second.
Yeah.
A lot of land also often is held in trust. It's restricted or in trust. Either way, there are restrictions on alienation, but there's a lot of land that's also held in trust at this point.
Yeah,
because it was
good
held.
point.
Yeah. So if you see that, then it's don't be surprised. Sorry for the interruption.
No, interrupt anytime. Okay, so tribal trust land is land to which legal title is held by the United States in trust for the tribe. So, for example, the vesting deed would actually show the grantee as the United States of America in trust for, let's say, the Navajo Nation, for example. So the tribe in this scenario is considered to have a beneficial ownership in the property, again, similar to that trust relationship that was created through allotments. At any time, a tribe can file an application with the Department of the Interior to have land they own in fee transferred to the United States to be held in trust for that tribe. There are regulations governing this process that have to be followed. It's referred to as a fee to trust transfer commonly. And the BIA has a handbook on their website outlining the steps for that process. The application that the tribe submits for a fee to trust transfer can be for land that the tribe owns in fee either on or off reservation, so it doesn't have to be on the reservation. And that fee to trust transfer can be discretionary, which means the Secretary of the Interior has the ultimate decision-making authority to accept or deny the application for that acquisition. But it can also be a mandatory acquisition, which means that the acquisition is directed by Congress or a judicial order, which requires the Secretary to accept the land into trust. And I mentioned this earlier, that the application for a fee to trust transfer can also be coupled with a request for a reservation proclamation. If it's approved, the reservation proclamation can add property to an existing reservation, which is more common when a tribe has acquired land that's immediately adjacent to their reservation in fee, and then they want to put it in trust and make it part of their reservation. So one thing that's important to note for us as title insurers is, due to a change in the regulations that govern the fee to trust process in 2016, a title insurance policy is no longer required for a fee to trust transfer. Whether or not a policy is purchased is really up to the local BIA agency office that's processing the application. But when the acquisition is insured and they do want a policy, it's typical to use a U.S. policy, since the named insured is the United States in trust for the tribe. So I kind of cruised through this slide without really showing much of it, but it's in your handout. So individual trust land includes allotments and fee to trust transfers on behalf of an individual Native American, both of which have been discussed in the prior slide. Same, process for the fee to trust transfer, submitting the application. Individual acquisitions are also discussed in that handbook that I mentioned that's on the BIA's website, and they are very good about updating that as the regulations change over time. Okay, so tribal fee land includes land held in fee ownership by the tribe with no trust relationship present and no express restrictions on alienation. And I say there's no express restrictions on alienation because there's some ambiguity as to whether or not the Indian Trade and Intercourse Act of 1790, which is commonly referred to as the Non-Intercourse Act, is applicable to land held in fee by a tribe. That act restricts tribes from conveying, leasing, or encumbering their land without congressional approval or treaty rights. And it's confusing because there's varying federal court decisions that speak to the applicability of the act on land the tribe independently acquires in fee. So without clarity from a Supreme Court decision, it's pretty much up to each individual title insurance underwriter to establish their own underwriting requirements for insuring transactions involving tribes who want to convey, lease, or encumber property that they own in fee. Individual Indian fee land includes land that's owned in fee by an individual Native American that is no longer or has never been subject to any restrictions on alienation. Let's see. yeah, talk about surface leasing for a little bit. It's really common for tribes and allotted lands for tribes to lease land they own and for allotted lands to be leased. The reference Long-Term Leasing Act there on the slide is the most prominent statutory and regulatory authority for leasing on trust or restricted land. And it's really important that you pay attention to the term of the lease, which is really specific under leasing regulations. The Long-Term Leasing Act requires approval of the lease by the Secretary of the Interior, and additionally, the federal approvals trigger a requirement for compliance with federal environmental protection laws. And I've got a few examples here disclosed on this slide that's in your handouts as well. Okay, the Hearth Act is an acronym for Helping Expedite and Advance Responsible Tribal Homeownership Act. So if the tribe has leasing regulations that are approved under the Hearth Act, they can enter into the leases without secretarial approval. And it also has limitations on the lease terms that need to be closely observed. There's other statutes that authorize leasing besides 415, and there's also caveats built within 415 for certain tribes. The statutory authority that the tribe is relying on to enter in their lease should be disclosed in the actual lease itself. So, getting a copy of the lease and reading it like you typically do when you're insuring a leasehold interest is very important. It's important to understand what leasing regulations the tribe's relying on so that compliance with those regulations can be confirmed when you're ensuring the validity of that lease. Nancy, did you have anything to add on that section before we move on to title searches and recording?
Well, just a couple of points. One, there is a very small group of Hearth Act tribes. In other words, there's a small group of tribes that have actually gotten their leasing regulations pre-approved. And I think that it's under 40 at this point. The list changes periodically, and I just saw something in the Federal Register that indicated that another tribe came on board. The Hearth regulations are applied to residential and or business leases. So you may have a tribe that has Hearth Act regulations just for residential leases, or typically it will have them for residential and business. I mean, it's fewer of the tribes actually have just business regulations. But I think there's an inquiry that should be made if you're dealing with the lease, just with the tribe. Is this a Hearth Act tribe? And there is a list on the BIA website, but it's typically not current. So beware of that. The other types of leases that are covered by federal law but are not, when we talk about surface leases, I mean those include business leases, residential leases, ag leases, solar and wind. So the regulations were expanded a few years ago to include solar and wind, and they were totally rewritten to streamline them allegedly. But so those are the two things that I would add there. Just those are areas of inquiry. The regulations are important to look at if you're dealing with the creation of a lease. And do remember that unless there's a Hearth Act involved, the federal government must approve the leasing that is considered to be a form of alienation of Indian rights, and per the Non-Intercourse Act, it may only be accomplished by an act of Congress, which of course is the Long-Term Leasing Act, which permits the alienation for surface leasing. That's it.
Okay, thank you.
Mm-hmm.
Okay, I'm going to touch on title searches and recording. And a good place to start is by talking about the BIA Land Title Records offices. This is where all the documents affecting title to lands held in trust or restricted status are recorded. And to be clear, there's no requirement that the documents affecting title to lands held in trust or restricted status be recorded in the local clerk and recorder's office. Those documents are maintained by the LTRO in a totally separate location. So that there's the regulation that talks about that. And, there's just a note there that the process for submitting documents to LTRO varies from region to region. A lot of things about the LTROs tends to vary depending on which LTRO office you're working with. This slide right here lists all of the land title records offices, and please note that there's a list of regional land title records offices as well as tribal land title records offices. The BIA provides oversight for those tribal LTROs, but they are maintained within the reservation usually.
Well, and let me just add right there. The tribal LTROs exist because the tribe has contracted with the Bureau of Indian Affairs to take over the function of maintaining the land title and records for the particular tribes listed. Some of these tribal offices, and I apologize for not having a more specific list of them, there are tribal LTROs that keep records for more than one tribe. But this is a contracting function with the federal government, and Megan, I think, was being gracious when she said that the BI oversees these offices. I'm candidly not at all sure how much oversight is done in these offices, on the tribal offices. For example, I'm fairly certain that the Agua Caliente office is pretty much its own show. I think that would be the case for, it could be the case for other offices as well. Remember that the sort of separate note, the land records are owned by the federal government. If you look at 25 CFR Part 150, which is the land title and records section, you'll see language in there that actually says that the records are public. And you might say, well, I should be able to, search them readily. Well, they're not, as a practical matter. These records, because they're owned by the federal government, are subject to the Federal Privacy Act, which means that access is restricted per what the federal government calls a System of Records Act notice, or records notice rather, or a SORN. And it's a policy by the feds that it says who may have access to the records. And I am sorry to say that direct access officially is not available to title companies, to the title industry. Unofficially,
and I have a slide talking about how they can get access to those records.
Yeah, exactly.
So very
unofficially, unofficially, you can get access, but officially, not so much. So, sorry, again, interruption.
That's okay. So just that's this regional office map. It's a little difficult to see, but hopefully in the handout you can blow it up and see it a little better. It gives you an idea of how they break up the country regionally for the LTRO offices. And so, going back to the comments that Nancy was saying, so, you might be wondering how you access these records if you can't locate them in your own search at the clerk and recorder's office. In order to access them, a TSR, which stands for Title Status Report, has to be ordered from the appropriate LTRO. And the LTRO has their own examiners who prepare the TSR and identify documents recorded against the title to the property. They all operate a little differently. Some LTRO offices require you to place your order for TSR through the local BIA agency office, who in turn passes the order on to the LTRO. Some require that the property owner place the order, and some are more flexible and allow a title company to place the order for a TSR directly with the LTRO. So, it's imperfect. You just have to reach out to them when you need a TSR and find out what their requirements are. So if a tribe or an individual Native American owns land and fee with no restrictions, There is no requirement for documents affecting the title of the property to be recorded in the LTRO. Also, once a parcel of land is no longer subject to restrictions on alienation or that trust status is terminated, the LTRO stops maintaining records for that property, and they won't issue a TSR for any fee land. So getting historical records from when the property was held in trust or restricted status is not an option. Okay, so let's move on to our last topic here so we can still have some time for questions. I'm going to give you some information about access, and Nancy is going to give you a couple of good examples of scenarios where access became an issue for us. 25 CFR 169 outlines the regulations for obtaining a right-of-way over Indian land. Right-of-way is a general term, but for title insurance purposes, we would consider that to be an easement. These regulations affect land held in trust or restricted status and BIA land, as noted on the slide. And as I previously noted for leases, the right-of-way regulations also contain specific term limitations. That's important because an easement granted for a roadway that provides access to the property will expire. So when you're relying on an easement that's been authorized under these regulations, the terms of the easement should always be reviewed so you can check for compliance with the regulations as well as whether or not the easement has been terminated by expiration. If the land is owned in fee by the tribe, they grant the easement, but again, you need to consider applicability of that Non-Intercourse Act. And when the land is owned in restricted fee or held in trust by the United States, the easement's granted by the Department of the Interior, but the tribe or individual Native American owner must consent to the grant. Let's see here. So when you're relying on access through reservation land, it's important that you verify you have valid unexpired easements over any land that's owned in trust or restricted status. Even if a road is labeled county road, the roadway might be improved in reliance on an easement granted under the right-of-way regulations due to the fact that the underlying fee is held in trust or restricted status. So even if it's a county road, the easement could be expired. So that means that it might be appropriate to examine access rights from your subject property all the way outside of the reservation. And another unique challenge when ensuring access on or near a reservation is the creation of checkerboard reservations. So I'm going to turn it over to Nancy here for a discussion of checkerboard reservations and some examples of access issues involving reservation land.
Checkerboard.
Go ahead, Nancy.
Thank you. Checkerboards can be the result of the Dawes Act, which recall was the act pursuant to which the federal government broke up reservations and allotted land to individual Native Americans and basically took it out of tribal title except for the quote surplus land. And then the allottees were allowed to sell their land and did in many instances. So you have the diminution of the whole of Indian country. But then also, if you look at the next slide, on slide 51, the checkerboard also was created by when reservations were created. I mean, and this example, in some instances, this example is the Agua Caliente Reservation in Palm Springs, California. And when this reservation was created, somebody came up with the idea that every other section should be Indian land. So you literally have Indian land, non-Indian land, Indian land, non-Indian land, literally a checkerboard here. Other reservations are not nearly as this geometric. Generally, they're not this geometric, but there is nonetheless a mixing of types of title, and there can be not only Indian title and non-Indian title. There can be federal land, there can be state land. They can be a mix in reservation within the exterior boundaries of reservations. I mean, typically though, it will not be as pretty as this one. If we look over, in fact, I want to look over. Let's look first, Megan, at slide 59. Okay. This is the simpler of the examples. I'm sorry, 54, excuse me. flip over two more.
Let's see, this one?
That one. Okay. So if you look at this slide, this is an example of a subdivision that was built around a lake, and you've got a public road off to that's running north-south on the western part of the subdivision. There are lots of lots here, so there are lots of opportunities to issue title policies. Then if you look the way this kind of in reverse C goes, you've got in the south east corner of lake, where we've got the lots highlighted in yellow. You see, you've got a road that goes across non-Indian land, because we have the Indian land labeled. The road that goes across non-Indian land, but then takes a turn, goes northwest across the corner of Indian-owned land, and then goes due west, or pretty much due west, across a whole bunch more lots, which may have their own internal right-of-way or easement agreement. You have to create a common easement for the roads and common maintenance agreement. But then you see where you've got at the far, the most westerly part of this little road, and where it butts into the public road. You've got the road very close to a parcel of Indian land. And so the question is, does it encroach or does it not encroach? And do you need to get a right of way? Remember that I said that one of the rights tribes has is the right to exclude. And that means that if you do not have permission to be on Indian land, you're in trespass. Just like if somebody used your land without your permission, either to put a road over or a fence on or a wall, that person would be encroaching on your land and would be subject to a claim of trespass. The difference is that on private land, there is the doctrine of adverse possession, or prescriptive rights, applies under various iterations under state law. Those concepts don't apply in Indian country. So you can't get prescriptive rights in Indian country. You're in trespass if you don't have permission. So if you look at the subdivision, the folks in the southeast corner, they're fine until they get to where the Indian land starts, but each one of those lots needs access over Indian land in order to get out of the subdivision. It's the only way out. And also notice the public road runs across fee land south, and then it also goes into Indian land. And so that brings into the question, as Megan mentioned earlier, is whether or not the county or state road was actually properly granted. So as I said, this is not an atypical situation where you have a checkerboard situation. And there can be a lot of trouble to be had when you're insuring multiple lots in there. So whoever insured the guys in the yellow area need to worry about access for those folks. Maybe the folks who insured the folks up in the northern part, north of the lake, may not, except to the extent that anybody figured, if it's determined that the road actually encroaches on Indian land. So that's the easier example. If we go back, we have a couple of Google maps here that I want to show you. Okay, the land on the right in green is Indian land. The land on the left is not. So, this is the adjacent. This is sort of a very nicely geometric adjacent situation here. Okay, so if you start at, and then on the top, it arcs across the top section or top portion of the slide. You see a road that's a 2 or 4 lane road up there that is a nice, quote, public road of some manner. And it's a little hard to see, and I apologize for that, but there's a road that runs basically due south across the green part of the slide, due south, and it goes to the west of this development that's sitting out there, and then it takes a jog to the west and then goes back to fee land. Now, the question is, are there rights of way for this entire road that is on the Indian land portion of this slide, which is the green side, in order to give access to anybody who lives off of the road on the non-Indian portion of the slide? And actually, you can see the non-Indian portion starts, it looks like a big umbrella there for some, it's kind of an odd notation. In this particular, and there are a variety of ways to research this. I mean, you need to go back and the research would involve, or the due diligence would involve trying to figure out if there's a right of way ever granted, and if it were granted, whether it expired, and if it did, and if it did expire, when it expired, or perhaps if some of this land was not tribally owned but Latie owned, it could have been conveyed out to a third party. So there are lots of different levels of inquiry, but when you look at this, you've got a question about access. If you go to the next slide, Megan, please. You can see the dark lines on this slide. This is the same little jog to the west that I showed you on the previous slide. The section lines are in dark black. So you've got a north, south, and east, west section line. Everything to the north of the east-west section line is Indian land. Excuse me. Everything to the north, I'm going to say, is currently not Indian land. The land to the south, which is on this little jog to the west, that happens to be on Indian land. And then if you get over to the north-south section line, it crosses over again to non-Indian land. Turns out there's a guard shack and a gate on the Indian land, and so you have it becomes a conversation about how to resolve if it's necessary to resolve if there is no existing right of way on this property because it's expired or there never was one, whatever. So these are kind of the complexities that you can get into that are real life, and depending upon where your property is. Okay, now that's the end of my comments, and I hope that wasn't too confusing. The slides are a little tough to follow, and without being able to ask questions. So, are there questions?
All right. Well, Nancy and Megan, this is Jeremy. Thanks for some of the great information. Really enjoyed the maps as you kind of showed how public access and roads can be affected by when they cross public roads or a lot of noise in the background, or Native American land. We have had several questions come in. We'll try and get through as many as we can. We are near the top of the hour. We'll probably go a little long, maybe, if you want to hang out with us as Nancy and Megan answer some of the questions you guys have submitted. I'll just fire some to you guys, Nancy and Megan, if that's what we want to do, and we'll just do kind of knock some out. First question from Phil, and he's asking if Public Law 280 grant those specifically identified states jurisdiction on just certain legal and regulatory matters rather than impose state law for all purposes on tribal land.
The Public Law PL 280 applies both to civil and criminal jurisdiction in some limited ways, and it's not it's a specific grant with some exceptions, and it is not it's broad. And if you're in a PL 280 state, I would highly recommend that you take a real hard look at the statute and any local cases about its interpretation. It
can vary by state.
It can vary by state. And there are some states that have dropped out of 280 as well. So 280 is really an aberration, frankly. But that's why it's important to know that it's out there. And I hope that answered the question. But it is a broad grant of jurisdiction.
Jeremy, just because we are approaching the top of the hour, I'm going to, just advance one slide so people have our contact information in case they have to drop.
Yep.
but we can continue to take questions.
Yeah, thanks, Megan. And yeah, feel free to reach out to either of the speakers. You can download the presentation at the end of the handout section as well. Next question here. Since we often place significant reliance on the legal principle of our typical insured being a bona fide purchaser or encumbrancer for value under state law on non-Indian lands, are there similar protective laws on any or all Indian lands? And if not, shouldn't that be a significant consideration when insuring on these lands?
Yes, it should be a significant consideration, especially when you are being asked to give extended coverage. You don't know that you have the same kind of BFP protection or body of law that you can rely on when you're considering assuming that risk in an off-reservation, typical non-native, fee or leasehold transaction. And so you can't assume that you have BFP protection or that same kind of established law when you're on a reservation. And you might be subject to tribal law or jurisdiction. And so that's something that needs to be carefully evaluated when you're being asked to give extended coverage or take on other types of risk where you would rely on those types of legal doctrines or, established law to mitigate that risk.
And remember, you're not subject to state law. You're subject to tribal and federal law, or federal and tribal law, when you're on the res. So that those doctrines won't necessarily transfer. The tribe may have adopted them, but they won't necessarily transfer from the state by any means. And also remember, if your underlying transaction required federal approval and you did not get it, everything that follows fails. For example, let's say you had a lease that wasn't properly approved by the Bureau of Indian Affairs, Secretary of Interior through the Bureau of Indian Affairs. There was something defective about the approval. And there are a number of cases on this very point. And then let's say that you have subleases where you have development agreements or whatever that flow from that lease, or you have a sublease, or whatever it happens to be. Those also will fail. So even if the person who entered into the transaction had no knowledge and what might otherwise be a BFP, it doesn't work in Indian country. It's a strict. I don't want to say it's a strict liability, but it is. It's kind of similar to that in that regard.
Maybe kind of a similar question down this lane of risk and liability. Can there be off-record interests on these lands? Easements, covenants, mechanics liens, rights.
Mechanics liens are an animal created by state law typically, unless there's if there's a tribal mechanics lien law, then certainly you worry about it. But mechanics liens are again state-based. However, so there's some issue about whether or not they actually apply in Indian country. There are a couple of cases floating about that indicate that that they do or don't, whatever. But I know that it's uncomfortable if there's a break in priority to insure if you've got a mechanics lien issue out there. I mean that becomes that's an issue that would need to be looked at. It seems to me. Off record.
Some tribes have their own mechanics lien law embedded in their tribal code.
Yep, they do.
Which might need to be considered as well, and it might not necessarily comport exactly to what state law in that area, holds. So paying attention to whether there's any mechanics lien law contained within the tribal code is important when you're considering assuming mechanics lien risk, and of course that's impacted by how the property is vested and all of those things as well.
Well, sure. It depends, I suppose, on where the contractor is, and if the contractor decides to file a lien in the state, instead of with the BIA or the tribe, So it could become dicey in terms of other off record. Mechanics liens are probably the biggest ones, but there can be off record. But I mean, some people might consider the BIA records off record, but they in fact are on record. But I think probably the mechanics liens is probably the biggest one, at least certainly one to worry about, or to consider. I should say worry about, to consider.
I mean, of course, there could be records that somebody hasn't properly filed with the LTRO or the, clerk and recorder, depending on how the property is vested and what's required. So, you still have to consider when you're giving extended coverage or providing insurance for off-record matters, what kind of risk you're assuming if somebody hasn't, taken that easement down and filed it with the LTRO like they were supposed to.
Well, and also let me just add one quick thing, and that is there is a presumption that you are in trespass unless you have a right-of-way in your hand. So even if, somebody's been using the road for umpteen years and no one's questioned anything, if there's not a right-of-way that can be produced by an individual using the road, or if it's not in the BI records, then there is a presumption that it doesn't exist, even though everybody thought it existed. So in essence, you're kind of proving a negative. If you're out there in Indian country trying to show that you've got access, if you don't have the piece of paper, you can't prove it up, and no prescriptive rights. So.
Let's do a couple more. We are, six after. I'm not sure if anyone, if you Nancy or Megan have another meeting or anything to get to. But how would a title agent even know that they're dealing with a transaction involving Indian land? Would the seller advise them? Would this information be found in a title report?
Well, it's not one answer. It sort of depends on what materials you have available to you. So sometimes, yes, if you're using a starter or a prior and you see exceptions in that prior indicating that you're on a reservation or dealing with a Native American component, that will be your tip-off. Sometimes you can tell simply by the way the property is vested. I mean, if it says the title is vested in the United States of America for the benefit of a particular tribe, obviously, you've got some tribal issues. Sometimes, the taxes of the assessor's office, will have an indicator or be an indicator that you're within a reservation. Some people, in their title plans have markers on maps. And so it can be a variety of different things that trigger that knowledge that you're dealing with land that has a Native American component, and there might be special things that you need to consider, but it's not just one particular thing where we can say, go to this website and it will tell you. There's usually a tip-off in your examination process.
Okay. Here's an interesting question. How do the tribal laws and state laws interact when fee title to surplus allotted land? I'm not following the question here. Inside reservation boundaries was conveyed by patent from the U.S. to non-tribal individuals. Mm-hmm. Does tribal law or the BIA still factor into those titles?
Typically not. There's a whole body of case law that goes to how tribal law impacts fee land within a reservation. There's one of the cases, if you want to look at it, it's the Atkinson Trading Company case that involved Navajo, involves taxes. There are a variety of other, there are other cases that speak to this issue. But the fee land within the tribe, within the reservation, again, it's important to know how the tribe feels about this, candidly. But the overall, the general rule should be that the fee land is not subject to tribal law. But remember, to get on and off fee land, you're going to have to go over tribal land or Indian land. So as a practical matter, there may be issues that you need to deal with. But and also there are jurisdictional issues over non-Indians within reservations. Tribes have jurisdiction over their members. not even necessarily over other non-Indians, but certainly not over, non-members, certainly not over non-Indians. Again, there's a body of law that speaks to when tribes have jurisdiction over non-members, and the line of cases, in case anybody wants to follow, it's called the Montana cases, and like the state name, Montana, and Montana sets forth two exceptions to the doctrine or the rule that tribes do not have jurisdiction over non-members. And then there's a line of cases that flows from Montana, talking about when tribes have jurisdiction and when they do not have jurisdiction. So the answer is not simple, unfortunately. But when it comes to the conveyance of fee land within the reservation, if it's not vested, if it's vested in a non-Indian fee, that land it should be freely alienable. But again, you may have an issue with the tribe and access, and whether the tribe is willing to continue to grant access to a new owner. And that sometimes is a practical issue that has to be dealt with.
All right, we've got just under 250 people still with us. So.
Oh my goodness.
Yeah, pretty engaged audience here. If a property becomes fee and the LTRO no longer contains records, is a title company able to insure when they aren't able to complete a full title search?
Well, I think this question, I'll answer this, Nancy, because this comes up for us all the time when we're examining. Once the property, like I said in my prior slide, comes out of trust or restricted status, the BIA just, puts the wall up on maintaining records for that property within their LTRO offices. And if you were to reach out to the LTRO office, I know this because I've done it many times, and say, I'd still like to get a title status report because I know that before this property became fee, it was held, in trust or restricted status. So I'd like to see the old records that have been filed in the LTRO pertaining to this property from that time frame. They'll say, we can't help you. We don't have those records anymore. We don't know what happens to them. I mean, we've talked about this within our ALTA committee several times. They simply say we can no longer generate a TSR. The property is now in fee. We don't have access to those records. So you're not going to get them. They don't maintain them. They won't produce a TSR. So, it's up to each individual underwriter how they want to address that. Is it a risk that they're willing to assume because no one can get access to the records? Do they want to include some kind of exception for it? I mean, it's a company by company decision on how they want to handle that. But the answer to the question is you will not get those records once the property has been converted to fee.
But what you can get is the conveyancing instrument from trust to fee. There's a process for allottees to sell land. Now, in this instance, you're not talking about tribal land because tribal land doesn't get sold if it's in trust, unless they take it out of trust. And that is, I don't know. I mean, I don't even know of an instance, candidly, in which a tribe's taken land out of trust. But allottees take land out of trust. They convey land, and there's a process for a trust to fee transfer. And that trust to fee transfer is made there's a conveyance by the BIA, which is given after application by the allottee, and a whole lot of rigmarole that everybody has to go through to get the property out of trust. So there is a conveyancing instrument, and I'm trying to think, the most recent instrument that I saw come out was subject to restrictions, reservations of record, or some easements of record. So that broad exception that makes all of us crazy because it means everything and nothing. But you can at least get that document. But the prior records, forget about them.
All right, let's do one more question, and this is about fee property as well. Does adverse possession apply to fee property that lies within the boundaries of a reservation, or are all properties within the reservation boundary excluded?
So how would you? Well, I'm trying to think. When you say adverse possession, so you have a piece of property. Megan has a piece of property in the middle of Navajo, or whatever, or one of the whatever reservation, and she owns the property outright. And I decide that I'm going to go be a squatter on that property, and I live there for, let's say, the requisite number of years under state law. Open and obvious, whatever the 10 years or whatever the prescriptive rights are. I would think in that instance, maybe, but honestly, I have never seen that happen. I have never encountered that situation. I might have a better answer in the future, because I do know of a case in which some folks are claiming prescriptive rights over a road, and it will be a local case, but it'll be interesting to see how the court comes down. But I do not know. I don't know the answer to that, honestly. Megan, have you ever run into it?
I think it's, this is obviously, speculation on my part, but I would say if, you are a non-Native American owner of fee land inside the reservation, and you are making an adverse possession claim against, property, let's say, that's owned by your neighbor, who's also a non-Native American fee owner within the reservation, then you would likely have success in state court trying to get a judgment for an adverse possession claim. But if you're trying to assert adverse possession against a tribe or
a native or
owned by the tribe, then you're not going to have any luck. So I think, and then there's an interplay with how Public Law 280 is, how it impacts your state, if at all, I think. But if you don't have any reason to engage the tribe or make a claim against tribally owned property, then I think your chances of succeeding in an adverse possession claim are higher on fee land, even if you're inside the reservation.
That assumes that your judge doesn't say, "Oh, your land is inside the reservation. I don't have jurisdiction," because the judge doesn't understand that it's not Indian land, which can happen. And you have to convince the judge that the judge does have jurisdiction over that particular piece of land, because it's not Indian land, even though it's within the boundaries of the res.
Which is kind of the Public Law 280 interplay a little bit, right?
It is, unless you're not a Public Law 280 state. And then you're saying the judge could still say that. Oh, well, yeah. Because they're saying, well, it's within the reservation, so it must be Indian land.
What you guys are saying, it's complicated.
It is complicated, unfortunately.
Nothing that's not complicated in Native American lands, Jeremy.
How about we wrap up with one that this might be a little bit more of a simpler answer, and the question is, can they rely on the policy from the trustee to fee in ensuring the next transaction?
From the U.S. to fee, I know people at the federal level who would say absolutely, and you don't even need title insurance because clearly the deed's from the United States. I've had people at BI tell me that. That's for me. I don't underwrite, however. I'd have to leave that to Megan. And my feeling is it'd be an individual underwriter decision.
Well, Megan, maybe I don't totally understand the question. Is the question if they follow the trust to fee process, can you rely on that as a valid conveyance? I don't think I completely understand the question.
Yeah, I think that's the question.
Without getting the records behind it, I guess it would be.
Yeah. Mm-hmm.
Okay. Yeah, I think that's the same question that was asked previously, just in a different way.
Yeah.
What if you can't access the records once you're in fee? What do you do? And I do think it's the same, answer I gave before, that it's sort of up to you as an underwriter how you want to address that risk of not being able to access the records that were previously maintained by the LTRO.
Mm-hmm.
Okay. All right. Well, Nancy and Megan, thanks again. And thanks you all for hanging out with us for an additional 20 minutes. There were a few more questions that we didn't get to. Again, the contact information for both the speakers is on the screen. If you missed any parts of today's webinar, if you think others in your office would benefit from listening, we will have a recording to the presentation available for replay tomorrow. You'll get an email with a link to access that. Also, if you're interested in joining ALTA's Native American Lands Committee, please reach out to Nancy, as she is the chair. And looking ahead to next month, we will focus on how title companies can work to build their talent brand. So mark your calendars for May 22nd and be on the lookout for registration information in the next few weeks.
Jeremy, were you gonna send a Survey Monkey out about any, or did we just, or not, about possible future programs that people are?
Yeah. It's just a one question
Okay.
survey question. It's saying if you'd like additional education webinars, information about native land. So a simple yes or no, and that way we can know if you guys are interested in more of this content. All right. Well, with that will bring us to the conclusion of today's presentation. To wrap up, just need to thank Fidelity once again for sponsoring our Title Topics webinars. And also, I've been asked to give a reminder, a little plug for the ALTA registry, and make sure that your title company or law firm is confirmed in the registry. Being an ALTA member or having a policy forms license does not mean your company is automatically in the registry. So you can go to alta.org/registry for more info and to verify and see if your company is there. Nancy and Megan, thanks again for taking some time out of the day and helping us learn a little bit more about Native American land.
And thank you all, and thank everyone for calling in.
Thanks, Jeremy. Yep.
Thank you.
All
Take
right.
care, everyone.
Good afternoon, everyone.